1, I call the meeting of the House and Children and Family Affairs Subcommittee to order. Haley, would you please call the roll?
Vice Chair Bricken. Here. Chairman Carter.
Here.
Vice Chair Eldridge. Here. Gillespie. Here. Harris.
Here.
Stewart. Chairman Littleton.
Here. Thank you, Haley. Do we have any personal orders? Well, I'm going to take one for Chairman Carter and welcome Joan Carter, his lovely wife, here today. We're glad you're here with us. So next we're going to go to item number 1, which is House Bill 62 by Representative Carringer.
Second.
Being properly motioned and second, Representative Carringer, you are recognized.
Thank you, Chairman. I was wondering if I was going to get that second there. Thank you, Chairman, and thank you to the members. This bill, House Bill 62, was brought to me by the administration, and I'll just tell you a couple of things about it, and then we have some from the administration that can speak if you have any questions from that. Actually, what it's doing, it's deleting the advance notice registry, contact veto registry, and revises provisions related to the sealing of adoption records. The advance notice registry allows an individual 15 days notice before an adoption record is released to their biological child. And then we have the contact veto registry, which allows a biological parent to identify if they want contact with that child. So I just gave you a little brief description of it, and I'm here, and I've also got some others here that can testify or answer any questions you might have.
Thank you, Representative Carringer. Are there any questions? Hearing no questions, are we ready to vote?
I call a question for our.
Call for the question. All those in favor of House Bill 62 moving out to civil, say aye.
Aye.
Those opposed, no. Very good for your first bill.
Thank you. Wow.
House Bill 62 moves out to civil. Very
Thank
good.
you.
I should have mentioned that. Next, we have item number 2, House Bill 93 by Representative Garrett. You are recognized.
Thank you, Madam Chair.
Here, properly motioned and second. You're recognized.
Thank you, Madam Chairman.
Oh, and we do have an amendment. Is that correct?
We do, and I will be asking for that amendment to be on the bill. It's amendment coded 3901.
Properly motioned and second. Are there any questions about the amendment? Hearing none, we're going to vote to put amendment 3901. Oh, you're recognized.
Could you give us the cliff notes, please?
Sure.
Thank you.
The couple words were revised. 2 or 3 words were replaced from brings or revive suits to, let me find it, to files a petition to open or reopen a decedent's estate. And then section 3 was added under section C2 that eliminates a process that I'll describe once we get on the original, on the amended bill.
Thank you.
You're welcome.
Any other questions? Hearing none, we're ready to put on amendment 3901 onto House Bill 93. All those in favor say aye. Opposed, no. The amendment goes on.
Thank you, Madam Chairman. House Bill number 93 as amended is brought to me by the TennCare Division, and actually I applaud them from doing this particular bill. As you all know, if you are a recipient of TennCare, when you pass away, your estate owes TennCare. TennCare basically carries a lien on your property until TennCare is actually paid off, depending on what is passed through the decedent's estate. That lien, as it exists today, is forever, which was a surprise to me. I do this type of work. The first thing I do when I open up a probate estate is I get a TennCare release, because you have to sell any property, et cetera, as part of the administration of the estate. But what this bill does is it makes that claim for TennCare to recover any money from a person's estate, it gives it a statute of limitations of 4 years. So they are cut off. If there's a TennCare claim or a potential claim out there that's older than 4 years, TennCare has no right to recover against that estate. So in my profession as a lawyer that does this type of work, this is a fantastic bill, and I applaud the Division of TennCare for doing this because they have backlogs, believe it or not, beyond those 4 years that takes manpower in order to service those. So this is going to free up their staff and committees to go after dollars quicker and hopefully recover those proceeds for TennCare earlier rather than later, because the collection process, as it gets longer and longer, is hard to recover assets for the Division of TennCare. So I think this is a very good bill, and I would ask for your support and pass the bill on to the Civil Committee. So thank you very much. I'll be happy, Madam Chairman, to take any questions.
Thank you. Are there any questions? Vice Chair Brickham, you're recognized.
Thank you, Madam Chairman. A couple of things, Representative Garrett. One, and I'm just going to start off with the math part. The fiscal note attached to this is $1 million decrease that's supposedly in the governor's budget. But in reading the fiscal note, it says for calendar years 2018 and 2019, there were more than 4 years old, total $3,277,000. Is that for over 2 years, or each of? I mean, it reads it like it's for 2 full 2 years. They would lose $3 million.
You're recognized.
Thank you, Madam Chairman. The idea behind that is that there's going to be some revenue loss, because there's going to be some, at times, estates that they do recover beyond that 4 years. So what they're going to lose some of that potential revenue, but the idea that the time and focus that it takes on an estate that's one that's that old, some of those assets get stale, they're either not collectible, and so they're going to use those proceeds in order on the front end to try to collect those dollars within those 4 years. And so that period of time, they're trying to basically guess on what they're going to save, but they're going to lose dollars in the beginning and hopefully save more dollars in the long run, because we're collecting these estates quicker. So we can put more forces on the front end of those 4 years rather than continue to look beyond those 4 years, because that time frame is unlimited on what they can go back.
Yeah,
Vice Chair Brickham, you're recognized.
I'm sorry, Madam Chairman. First of all, it just seems like the fiscal review got the math wrong. If it's 2 years, they should have halved it, and so the financial decrease should only be half of that, rather than the stated amount. So it just seems like you're carrying a worse, it's a worst case calculation there. I'm just throwing that out. I just read this an hour before. I would have.
Well, we'd be happy to provide any clarification on any issue with what revenue that we've miscalculated the fiscal note. I didn't calculate that fiscal note, but the bottom line to whatever we lose in the long run is going to be made up.
Should be.
In the short run by focusing on the estates that are more ripe, so to speak, that are less than 4 years old. Okay. And that's the idea behind the note.
Vice Chair Brickham, you're recognized.
The other is currently the collection. So when someone goes into a TennCare facility, nursing home, the state goes ahead and registers a claim on any real property, or puts in the county that person exists or whatever, and so that's the claim that when you open an estate, you try to get a TennCare clearance letter for. But if a claim a state is never opened up, or ever whatever, a notice to creditors is not published and all that stuff, which often happens. So does that claim just sit there? And, I mean, obviously the spouse or some family member will try to liquidate that real property. But the only way they can convey it without encumbrances is to get that TennCare clearance letter, right?
Representative Garrett, would you like for us to go out of session and let Ally would TennCare come up, or?
Sure,
you
if
wanna
that's
answer?
appropriate if that's okay with the chair, but if possible beforehand, I'd like to respond to his question, if that's okay with you, Madam Chair, just to kind of clear up the process. That be okay?
Yeah, you're
Okay.
recognized. Yeah.
All right, thank you, Madam Chair. When you open up an estate for probate, you don't necessarily file a claim where you would have a lien against the real property, because sometimes probate matters may not have a real property inside the estate. So by statute, there is a formal process when you open up a probate matter to file a claim. In fact, it's very detailed in the statute. You got to file it in triplicate. Everyone has to get notice. There is a formal way and a formal notice to all creditors that you're providing notice that you need to file a claim against the estate. TennCare has to do the same thing. If they have services provided to the decedent that by which they want to be paid back, they've got to file a claim in the estate just like any creditor would if they're a non-governmental entity. That process has to be done just like anybody else does. And so to address your question about real property that needs to be sold or transferred, you're not going to find a title insurance company that's going to insure the title if, one, TennCare has not been released, or potentially if there's not an estate opened up, because we don't know who can transfer that property. There's no one that has authorized by the court under state law in order to certify and say, I can provide a warranty deed or a quitclaim deed and transfer that property from the decedent to the proper heirs without the probate administration or a judge giving someone the authority to do that. And so they're going to have to probably most likely come back to the probate process anyway, which would then trigger TennCare's responsibility to either file a claim against the estate or at least deal with TennCare's potential lien. So there's a process already in place for that. And so sometimes this will clear up TennCare's ability to pursue any claims they might have, because they've only got 4 years from the date of death of the person that received the TennCare. So if the estate, which in some cases can be opened up beyond 4 years, TennCare would have no claim against this person's estate if it's beyond those 4 years. So that's what we're trying to clear up, that backlog. So I hope that answers your questions, but if it does not, I would welcome an opportunity for TennCare, if they're here, to discuss any matters that the committee may want to hear on this particular legislation. But I'll defer to the committee on that procedure.
Vice Chair Brickham, do you have?
I'm fine. I can talk after committee on some of my curiosity questions, but it has no effect on the bill itself, so thank you.
Thank you for
Chairman
your
Carter?
questions.
Yeah.
You're recognized.
I ran into this problem this year. Thank you, Madam Chairman. I ran into this problem this year. A gentleman died October the 23rd, 1968, and his house transferred to his wife by intestate succession. There is no lien filed. It's filed by operation of law. And if you're a lawyer, you know it's there, and you better take care of it. If you transfer that land without getting that non-taxable certificate, as I call it, I think there's a waiver. That's not the.
There is. You can.
Non-taxable certificate's about a 10-year-old phrase for how they used to call it, not current, but it's by operation of law, and you must correct it. Now, here's what's interesting. Even though this law was not in effect October the 23rd, 1968, I had to get with the state, get the archives at the state to open up and get a death certificate and submit it and allege that there was no claim made against that estate in 1986, and they wrote back and said, no, it's not, and here's your waiver. It took about 23, 24 days to get all that done, even though there was no way it could possibly occur. But when you said they file a claim, they do not file a claim. It is filed by operation of law. It is automatic. It is there. If they had to file claims on every estate, we'd have to have a 10,000-member staff over there. But it works very well, because if you're the one that transfers it, you don't have that release. Somebody will be knocking on your door one day, and you'll be writing a big check for malpractice.
Thank you, Judge Carter. I think without objection, we're going to call up TennCare and let them do a little explanation too, if you don't mind. So we're out of order, out of session. All right, out of order. Please introduce yourself and who you're with, please.
Thank you, Madam Chairman, members of the committee. My name is Drew Staniewski, and I am the General Counsel at TennCare. And frankly, I think Representative Garrett's done an awesome job explaining it. I think the real crux of the issue is once we're 4 years out from the date of death, TennCare claim goes away, and we want to make it also very clear that you do not need to file a release in order for that to proceed. And so the amendment actually was brought by the probate judges. They just wanted to make sure that was super crystal clear, that they didn't want people coming back and still trying to do the release process, which is, as everyone has mentioned, essentially required in every estate before it can be closed. And so this just really tries to wipe this out after 4 years and let people, go on and administer estates and not have this problem anymore. So that's really the goal. The one thing I would say, Representative Bricken, is the $3 million you mentioned in the fiscal note, that actually represents the total federal and state match. So the $1 million that's in the fiscal impact is the state dollars that are going. So,
Vice Chair Brickham, you're recognized.
No, sir. It's meant to show an average. So we basically it varies from year to year how the old cases, whether or not we get more or less. So.
Are there any other questions? Judge Carter?
She was in a desperate situation. We had to go back into archives to find the death certificate, and you all were just so kind to her and to work with us. And just as soon as I got the death certificate, you sent me I call them non-taxable certificates, and that's not the right word.
Request for release, form, yeah.
What do you call it?
Just a release. It's TennCare release, but we call it request
release.
for
But
release.
anyway, it was a tremendous burden to her, and you all were so kind to her. And when I called, you just seemed to drop everything in the world. It took about a month to get all this done, but somebody working 2 or 3 hours every day, and that just shows what this law will undo and stop is needless work. So thank you so much
Absolutely.
for that.
Thank you for being here. Are there any other questions? If not, we'll go back into session. Thank you for being here.
Thank you.
Representative Garrett, you are recognized.
Okay, I believe I will do my motion.
Are there any other questions?
If there's no other
Council?
questions.
Hearing none, all those in favor of moving House Bill 93 out to civil full, say aye. Those opposed, no. The ayes have it. You go out to civil full.
Thank you, Madam Chairman of the committee.
Next, we have House Bill 434 by Leader Lamberth. Leader Lamberth, you are recognized. Properly motioned and second.
Thank you, Madam Chairman. And there is a technical change on the bill. It's there's an amendment that's coded 003874.
Any questions on Amendment 3874? Hearing none, all those who have put in 3874 onto House Bill 434, say aye. Those opposed, no. The amendment's on. Leader Lamberth, you're recognized.
Thank you, Madam Chairman and members of the committee. So this bill came to me from Nikki Gozer. And Nikki used to work down here at the legislature. She was a legislative assistant for Curtis Halford, Representative Halford. And before she worked at the legislature, her husband was murdered right in front of her. They were doing a karaoke deal down on 2nd Avenue, and a man who was stalking her literally came up and shot her husband dead right in front of her. That man was convicted, and he went off to prison. Now, while he was in prison, you would think that a victim of violent crime of that point would be safe from that individual, that they would never have to think about that they would be able to deal with their grief and go about their life unmolested and not have to worry about it. But unbeknownst to Ms. Gozer, this individual who was convicted of murdering her husband was sending letters to her. The only address he had, thank goodness, was the address of her attorney. Years go by, and she did not know that those letters were coming to her. And these are bizarre letters. I did not bring examples, but these are letters no victim should receive, and very kind of all over the place, but very concerning. She found out about those letters a few months ago and was very, very, very disturbed. And one of the other things, when she reached out to me, and she knows that I've worked on several bills like this in years past to protect victims, just as Judge Carter and Chairman Littleton and others have worked on, and Representative Stewart, to try to keep victims of violent crime safe. She reached out to me and said, what can I do to keep this person from being able to contact with me? So we immediately started looking at orders of protection because, as Judge Carter knows, there was nothing in the original judgment that sent this man to prison that had a no contact. And that kind of makes sense because a district attorney, that person's attorney, the judge, would assume that wouldn't be necessary. This person went to prison. They got the maximum penalty that you could get for that. So you would think no additional orders would be necessary. But the letters kept coming. And so an order of protection was really the only thing that we could think of. And as, again, the judge knows, I mean, those are really more for more immediate actions that have occurred, and they're to be renewed yearly. I mean, that's kind of how an order of protection works. I mean, someone goes down, gets an ex parte order of protection, it's served on the individual, they have a hearing, and it's for something that probably has happened pretty recently. There's never a time in Ms. Gozer's life or anybody else's life that's in her circumstance where she should ever hear from this person again. It doesn't matter if it's next year, if it's 20 years from now. She should never hear from this person. So that's what this bill does. It allows for an order of protection to be granted by a judge. Doesn't have to be granted. The judge can hear the facts of the case, and there is a list of offenses that this would include. It is the more serious felonies that we limited it to that, such as aggravated assault, vehicular assault, second-degree murder, first-degree murder, virtually every homicide down through there, aggravated sexual battery, rape, aggravated rape. I mean, those type of crimes, the victim or victim's family member should be able to at least petition to a judge to be left alone forever. That's what this bill does. They would not have to renew that order of protection. It would be for a lifetime. It does allow for up to a year to serve an order of protection. That is a bit of a separate part of this bill, but it affects these order protections and everything else. There was an issue that came up in my district where technically right now you only have 15 days. This would allow for a year for the ex parte to be filed, but again, I want to be very clear on this. Law enforcement should file that as soon as possible. There are some folks that try to avoid that service, and under current law, if they were to do so for more than 15 days, technically speaking, the victim would have to start over again. So there is a secondary aspect of this bill that deals with the service of an order of protection. But again, that is to provide for, again, the protection of the victim to make sure someone's not avoiding process. That's what the bill does. I stand ready for questions.
Thank you for bringing this bill. I remember Nikki really well, and we've kind of done a little bit of emailing back and forth and texting. But no one should have to relive this the rest of their lives. It takes them forever to get over it anyway, but in between all of that, they should not have to be tortured this way. So thank you for bringing this bill.
Thank you, Madam Chair.
Vice Chair Brickham, you're recognized.
Thank you, Madam Chairman. Just, again, more of a curiosity question, but if they're a convicted felon in jail, what's going to stop them from doing this? Because what's the punishment?
Leader Lamberth.
Thank you for that question. It is a really good question. So if someone is subject to an order of protection, and if they violate that order of protection, they're subject to potential additional misdemeanor penalties, not felony, but misdemeanor penalties. If you are convicted of a misdemeanor and you are serving a felony sentence and it gets run consecutive to or on top of that felony sentence, it messes up all of your good time. It ensures that you will wind up spending more time in prison because you have a misdemeanor sentence out there that's waiting on you for when you are released on the felony sentence. And it has a pretty drastic effect on when you're up for parole, on when you would be eligible for release, having that misdemeanor sentence consecutive to. Now, a judge wouldn't have to run it consecutive to, but I would hope any judge that would find somebody in violation of this order of protection while in prison would absolutely tack time onto that sentence consecutive to whatever they were already serving. But that's the penalty. Now, obviously, if you have somebody that's serving a life sentence, there's not a whole lot we can do besides try to get TDOC to check their mail and insist. I say all the time, an order of protection is just a piece of paper, but it does show these victims that all of us have their back and that the entire court system has their back. So it is hopefully that extra layer of protection that would make sure that person knows you can't contact this other person.
Thank you. Thank you.
Judge Carter, you're recognized.
Thank you. The leader dealt with it because this is going to come up at every hearing because remember, this is a misdemeanor committed while in prison. And so when you try to get out or try and get an early release date, this would really mess you up. Secondly, it can be a grounds to move people. I had no idea that your location of where you serve your time is so critical. I used to have people call me and say, look, I'm 30 miles from my family. They come to see me every weekend. I got in a fight with a guy and he ended up dead. Now they've sentenced me. They're transferring me to Fort Pillow from Pikeville State Prison. I'm going to be 450 miles from my family. This is crazy. And so that's a very substantial penalty imposed. And so remember, this is the commission of a new crime in jail, and that really brings in a whole new set of disciplines. And so it's a lot more than just misdemeanor punishment. Thank you, Mr. Leader. We should have done this years ago.
Are there any other questions? Oh, you're recognized.
Leaders, I ended up drafting a bill somewhat similar to this one, and because of this bill specifically, I stopped mine. And so I don't know Nikki, but I do know a lot of other people, especially in my community, that this would truly help. And so I'm very, very grateful. I'm sure others will be as well.
Thank you.
Leader Lambert.
And I'd love to have your support on this bill and to have you co-sponsor and sign on to it, or anyone else would be interested. And I use Nikki's situation and her tragedy and her life as an example, but you're absolutely right. There are unfortunately thousands of victims that this can help throughout our state. It is not just Ms. Gozer, but it is definitely thousands of other people. She is just, I wanted to recognize her. She's watching today and wanted to make sure y'all know that that's what brought this to my attention, just as your constituents did with you.
Any other questions? Vice Chair Eldridge, you're recognized.
Just I guess curiosity. Let's say you have somebody in there, even though they piled on the misdemeanors and extra time, and this person is just determined that they're going to mail a letter out, they're going to send something out. Would it be that the Department of Corrections would monitor their mail?
Leader Lambert.
That's a really good question, a very difficult answer. There are lots of ways that a prisoner can get a piece of mail out. There are pieces of mail they can send to their attorney, to other attorneys. I mean, they have rights that they have earned through different federal lawsuits and decisions. It is a very intricate process. I know the Department of Correction tries to make sure to do that if there is a threat or if there is contact that's prohibited. I think that this gives them just an additional tool to be able to do that, because if a court has said, you know, this prisoner may not have contact with this person, it does give them, I think, more authority and a better ability to be able to do just that. But just because of the way a prison is set up, it doesn't make it impossible for, I mean, no matter how well they check, there's lots of ways for, you know, one prisoner to give a piece of mail to another prisoner and then mail it out for them. I mean, it happens. So again, that's the reason why it's, I think, important to put this in the law. But yeah, I know they try to do that, but it's a very intricate process.
Thank you, Madam Chair.
Any other questions? Are we ready to vote? All those in favor of moving out House Bill 434 as amended, say aye. Those opposed, say no. The ayes have it. You move out to civil. Full.
Thank you, Madam Chairman and members of the committee. Thank you all so very much.
Next is item 4, House Bill 100 by Vice Chair Jernigan. Vice Chair Jernigan, you are recognized. Properly motioned and second.
Thank you, Madam Chair. Members, House Bill 100, been working on about 3 years now, as the chair lady knows, and even Chairman Carter was involved last year. But last year we finally got all parties on board, and it went from about 4 pages to 2 paragraphs, but I'll take it. But then COVID hit, and so that's why I'm back here now. This bill requires a petition for the appointment of a conservator to now include 2 additional pieces of information: a search of the Department of Health's registry of persons who've abused, neglected, or misappropriated the property of vulnerable persons, and second is a search of the National Sex Offender Registry, both which are free. It's important to note that the results of the search do not automatically disqualify an applicant, but it does give the judge the information needed to have the right people in the right place when governing the legal and financial affairs of our most vulnerable. The bill goes into effect January 1st, 22, and I'll be happy to answer any questions we may have.
Are there any questions? Hearing none or seeing none, are we ready to vote? All those in favor of House Bill 100, say aye. Aye. Those opposed, say no. The ayes have it. House Bill 100 moves out to a civil full.
Thank you, Madam Chair. and members.
Congratulations.
Thank you so much.
Number 5, House Bill 200 is off notice. Do we have any announcements? I have one next week. Kevin Weaver with the Tennessee Bar Association Adoption Law Section could not make it this week, so he will be here to do a presentation next week. And also, I forgot to introduce Caitlin Pierce, our Chairman Carter's intern. We're glad to have you. We'll see if we can find some work for you next week. So, are there any other announcements? Hearing none, without objection, we stand adjourned.